back to the show. This is The Law Show on CL 650.
Hey, welcome to The Law Show on CL 650. I'm Zach Spencer. Today we're talking with personal injury lawyers Scott Stanley and Kevin Gourlay from Battista in downtown Vancouver. We're talking about the difference between our legal system and what we perceive to be our justice system. And what you're basically saying in the first segment is law isn't always just. People feel that the law lets them down in certain circumstances.
Yep, just like Mr. Strummer said moments ago. I mean, we fought the law, and it can be a tough day. There's nothing worse than telling a client there's nothing I can do for you. Mm-hmm. It would be like a doctor telling a cancer patient, I can't help you anymore. Mm-hmm. And I'm sure it's a similar feeling.
So when you have situations where you have to sign a waiver or you buy something and there's all that fine print, as lawyers you read that fine print and the lay people don't. So what kind of problems can arise from a waiver where you are out of luck?
I think for the most part, the general public doesn't understand how significant those documents can be. Most people.
How binding are they?
They typically are binding, and I think most people think that if they go bungee jumping, for example, mm-hmm. that the waiver might mean that if they fall down while they're walking up the platform and break their leg, that's their fault and they can't sue for that. But what it actually means is that if the bungee jump company there has failed to take reasonable care, has failed to update their bungee cord to make sure it's still safe, things that are wholly outside of the control of the consumer, that they still are giving away any recourse they might have. And the problem with that is that removes the incentive for the bungee jumping company to take steps to make sure that the service they're providing is reasonably safe.
The one I always think about is you buy the ski pass. I'll pick Whistler Blackcomb because they're the biggest here in British Columbia. And you go to Whistler for the weekend and you get your ski thing and you clip it on your jacket and away you go. No one ever reads the back of that ticket. It's full of all kinds of fine print. But if you go skiing down and you run into a tree and something happens, or run into the back of one of those snow machines or what have you, are you out of luck? I mean, what kind of recourse do you have? There's a problem with the chairlift. What can you do?
Well, chairlift is potentially a different category. But I mean, the good thing, if you're skiing at Whistler Blackcomb, you're probably skiing at one of the safest. Well, in my opinion, you are skiing at the safest resort in North America. So your chances of any mischief happening to you are really, really low.
But things do happen. I'm not saying that they, we're not trying to throw them under the bus, but things can happen.
They absolutely do. And we hear from people all the time that are injured at Whistler Blackcomb. And the bottom line is, if you're an adult over the age of 19 and you've bought a ticket, whether you've read it or not, the waiver language in there is likely going to be found to be applicable.
Even if you haven't signed anything or being asked to read it.
Correct. Yeah.
So just by buying a ticket that has the fine print doesn't mean that you've read it or signed it or agree to it.
That's correct. And the way the law is, as it's presently constituted, is that if there's a reasonable expectation that you should know that a waiver is going to be in place, you're going to be bound by it. You can't plead ignorance. A little bit different is, say you are going and you're going to a racetrack and you're going to race a motorcycle and you haven't done it before and you're signing up to do the race and you think you're just signing a roster sheet, and little unknown to you, you've signed a waiver, and it wouldn't be reasonable to think that you're actually signing a waiver. The waiver in that instance probably wouldn't apply. But on a ski hill where I think it's everyone, unless you're from Mars, right? Everyone should have an idea that there's a waiver that's going to be in play there. So the waiver in a ski hill is probably airtight in most cases.
Can you give me any other examples of times where you sign something, or you look at something, or you don't look at something and you're not covered?
Don't make Kevin talk about the zipline case.
There are famous cases with whitewater rafting companies where somebody's been killed while whitewater rafting. There's famous cases where people have been killed scuba diving. There are cases with ziplining. And I think British Columbia has the laws that are most favorable to the insurance industry, and that's probably because of the influence that
they have with ICBC?
Well, no, because it doesn't apply much to motor vehicle cases. More the power of the ski industry in British Columbia And that's why our laws are unfavorable to consumers in that. We were talking before about the difficulty of getting legislative change. And there's something called the BC Law Reform Commission that makes recommendations about changes to the legislation. And they did a report back in 1993 proposing comprehensive changes to the law as it relates to liability waivers. And they made a number of recommendations, such as you shouldn't be able to waive your right to make claims for injuries that are caused by things wholly outside of your control. Mm-hmm. So, for example, in the example I gave before, if the company has given you a faulty bungee cord, something you have no ability to inspect or control, the waiver shouldn't apply to that.
That seems to me like common sense, which is the theme of the show. What you think you're protected for, you might not be.
Correct.
And those recommendations were made 23 years ago, and there's been no change.
Because you would think that there would be, the onus would be on the operator to make sure that they're running inside the rules. So basically, if you have a waiver and somebody signs it, you can play fast and loose with the regulations surrounding your business. If it's bungee operator or a zip line or a ski hill, do you have to ensure that everything is safe? If you sign this waiver, you're kind of off the hook, aren't you?
Here's the scary thing. I mean, I think you've alluded to this, Zach. Most people don't know what a waiver is. Uh-huh. I've talked to people who were law students, and quite frankly, I didn't know what a waiver was until I was a practicing lawyer.
I sign waivers every week. When I take a test car out, I have to sign a waiver.
Most people don't know what it means. Most people don't read it. I actually had a linguist look at a waiver and say, well, what level of education would you need to actually understand this? And they said the opinion was you'd actually need to have a postgraduate degree almost at a PhD level to be able to understand what this waiver means. So they're very complicated. Regular people don't have any hope of understanding them. They're not explained to them. And that's why it's unfair. What's really alarming is that the companies, many of them are not regulated. So, for example, lawyers, doctors, engineers, all highly regulated, licensed, and insured. I can't have my clients sign a waiver to say, look, Mr. Smith, if I screw up your case, you're not able to sue me. I can't do that. Even though I'm highly regulated and highly insured, I can't do that. But basically, Barney's Wild whitewater rafting that's been in business for 2 days can have people sign waivers, and they are enforceable.
And the insurance industry has successfully made the argument that these waivers are the only thing that allows these types of activities to continue, that if they didn't have these, that the ski industry would be shut down, that whitewater rafting would not happen. And that's just not true.
Well, I can't see that being the case in the United States, where people are much more litigious. And
sure.
So ski hills operate and whitewater rafting places operate.
And exactly these kinds of waivers were banned in England years ago by something called the Unfair Contract Terms Act. And they still have all of those type of things.
So what is the Law Society doing I'm putting you on the spot. Like what is your profession doing to you're doing a show like this to shed light on it, but to fix it?
Well, I mean, we do what we can. Kevin and I had a zipline case, and I'll let Kevin talk about it. He was, well, because we lost, I'll let him say, I'll make sure that he was lead counsel on it. But we worked on it together, and you know, there is some legislation that would allow you to impugn waivers if they're unfair, and we tried that sort of backdoor route.
Which is what you say, you had a linguist come in and say, who could ever have read this and understand it?
Well, this was a different case. Yeah. I'll let Kevin tell that one.
Well, this was a case where 2 people were injured while ziplining. You couldn't see the bottom of the zipline from the top. It was controlled by people using walkie-talkies.
Right.
And they didn't walkie-talkie, so they sent the next woman down while the first had not made it to the bottom. So she's sitting at the bottom, and it pulls the line taut. So the one at the top goes much faster than she otherwise would. You're totally at the mercy of the zipline at that point. You have no control. And she slams at high speed into the one who's still helpless at the bottom. And because of the waiver that had been signed there, they had no recourse. And we went to the Court of Appeal to try to challenge that, but we're unsuccessful. Scott was referring to something called the Business Practices Consumer Protection Act, which is relatively new legislation that allows you to, in theory, challenge a consumer contract if it's unconscionable. But the circumstances the court has said in which you would be able to show a contract is unconscionable are very limited.
Well, there was a skydiving case out in the valley where the fella didn't strap the woman into the tandem hang gliding apparatus, and she slipped out of the hang glider and fell to her death.
And that's the one where he then tried to eat the footage.
Yes,
on the memory card.
The memory card, yeah.
And that's exactly it.
So you're saying and they were, I think, newlyweds or just been engaged, and the husband or the soon-to-be husband is watching all of this unfolding, and he's helpless while this woman is tragically falling to her death. So you're saying if you sign a waiver, the guy's off the hook because of this?
I don't want to comment on
yeah.
specific facts, but much of the time, yes. And the problem with that is that these are high-risk activities that can be done and should be done safely, whether it's zip lining or hang gliding or bungee jumping. If the right steps are taken, they're very safe activities. They're fun, and they should, consumers should be able to do them. But we want to make sure that the businesses that are offering them have a reason to take the steps to make them safe.
Well, my question to you is, are you paralyzed knowing what can happen and being in the personal injury business? Do you let your kids go and take any high-risk activities? Like, how do you, when you know this, how do you enjoy life, knowing that there's this possibility that if anything's going to happen to you, you sign a waiver, there's no recourse?
Well, I mean, the thing with kids, and this is when I said earlier, if you're 19, different game altogether if the person is under 19, because waivers don't apply to children because they can't contract away their rights.
Okay.
Unless they get a preemptive direction from the public guardian and trustee. So if a little kid signs a waiver, a parent signs a waiver on behalf of a child, those are not enforceable.
But if you buy a ticket at a ski hill for your child, are you then basically taking on that liability?
You're not, but say you put your kid in one of these ski camps or one of these sport camps, they make the parents sign a waiver, and this is what I think is unconscionable, because these companies, they're obviously getting legal advice because they're putting legal documents in front of their clients. They know or should know that these instruments are not enforceable against children, but yet they get their parents to sign them. And I think the reason they do that is because people sign it thinking, well, my child's hurt. There's no sense talking to a lawyer because, I've signed a waiver, when in reality that's not the case. So I think I find that personally unconscionable.
What we're seeing more of now are indemnity agreements where a company asks mom and dad to sign an agreement that says essentially you'll indemnify us as the company if we injure your child. So if we cause your child $1 million in damage, we might have to pay your child, but we can come after you for that $1 million. We haven't seen the courts interpret those yet, as far as I'm aware, and whether or not those are permissible, and I think that will be a fight we see in the not too distant future.
Well, I certainly always look forward to the Law Show because I learn a bunch, and this whole thing around waivers has been an eye-opener, and I'm sure people listening are probably shocked and stunned that this is allowed to go on. We're speaking with Scott Stanley and Kevin Gourlay from Murphy Battista. They're in downtown Vancouver. This is the Law Show. We're going to pick it up and find out a little bit more about a very interesting discussion and topic next on the Law Show.
There's more of the show still ahead. This is the Law Show on CIAL 650.